Cheerio, Emily. Care for a pot of tea?
A great way to kick off our episode for today. So we've traveled to Canada to learn about some of the similarities and differences of employment laws there. And we are now taking a journey over to England with our partner, Nick Elwell Sutton, who sits in our London office, who is going to join us for a great conversation about all of the differences and similarities in English and UK employment laws compared to the US. So listen in.
Welcome to Hiring to Firing, the podcast. I'm Tracey Diamond, a labor and employment partner with Troutman Pepper Locke, and I'm here with my partner and co-host, Emily Schifter. Together, we tackle all employment issues from hiring to firing.
Today, we're thrilled to welcome as our guest our labor and employment partner, Nick Elwell Sutton, who sits in our firm's London office. Welcome, Nick, and thank you so much for joining us. Can you start by telling us a little bit about your background and the types of employment matters that you handle in your practice?
Of course. Well, thanks, Emily and Tracey. I'm delighted to join you today to give you some insights into UK practices. Day-to-day, I cover the full range of employee lifecycle issues from recruitment and team hiring to employee relations, so disciplinary grievance terminations. I also do a good degree around whistleblowing, discrimination and restructures, as well as trade secrets and restricted covenant work. That's not non-competes. In addition, the UK, the data privacy rules known as GDPR are really quite involved, and there's quite a large overlap between those and the employee issues. So I cover that as well.
Today, we're taking advantage of Nick's expertise and focusing on the difference between U.S. and English employment law. And as we always do, we're taking inspiration for our topic from a TV show, and this time we're focusing on Downton Abbey. I have to say, I've watched Downton Abbey a while back, and I really loved it, and now I'm sort of motivated to rewatch the entire thing again. So happy to be talking about this show today. This British historical drama chronicles the lives of an aristocratic family, the Crawleys, and their servants working at their English country estate in the early 20th century. The popular series has spawned 3 movies, and at one point was the most watched series on both ITV and PBS. And while it looks a little bit like pure historical fiction, it is really a workplace story in a lot of respects, as we will soon see. So before we get into our discussion, Nick, though, one question our listeners may have is about how employment law in England compares with the law of the other UK countries. Are they all under the same system?
It's largely the same across each of the countries comprising the UK, but with some minor differences in Scotland and Northern Ireland. Most of the legal framework is common, though, so similar concept to federal laws in the US, but with some nuanced differences between England, Scotland, Wales, and Northern Ireland. For example, in Northern Ireland, employees gain dismissal protection after 1 year in employment, whereas in England, it's England, Wales, and Scotland, it's 2 years. There are also more significant procedural differences in the court systems, which run separately, but in practice for employers, that's not going to be too much of an issue.
So kind of like in the US where we have our different states, there's federal overlay and then differences depending on which country you're in.
It's exactly like that, yes. Very similar. So the federal equivalent is what applies across the entirety of the United Kingdom. And then we have the equivalent of the state laws for England, Scotland, and Northern Ireland.
That makes sense. Getting into our first clip, here, Robert Crawley, formal title Lord Grantham, the 7th Earl of Grantham, hires John Bates to replace his previous valet, Mr. Watson. Mr. Bates's arrival was met with a bit of a cold shoulder from most of the staff because he walks in with a pretty obvious limp, which they fear would make him unsuitable for the job, including even being able to climb the stairs to reach his room. So let's take a listen.
But how can you manage?
Don't worry about that. I can manage.
Because we've all got our own work to do.
I can manage.
All right, Mrs. Hughes, I'll take over. Thank you. Good morning, Mr. Bates. Welcome. I hope your journey was satisfactory.
It's fine, thank you.
I am the butler at Downton. My name is Carson.
How do you do, Mr. Carson?
This is Thomas, first footman. He's been looking after his lordship since Mr. Watson left. It'll be a relief to get back to normal, won't it, Thomas? I assume that everything is ready for Mr. Bates's arrival.
I've put him in Mr. Watson's old room, though he left it in quite a state, I can tell you.
But what about over upstairs?
I keep telling you, I can manage.
Of course you can.
Thomas, take Mr. Bates to his room, show him where he'll be working.
Today in the US, employers cannot decline to hire somebody because they perceive they might have trouble performing a role because of a disability. In other words, they can't regard someone as disabled, and there may also be the obligation to reasonably accommodate a limitation. Is that also true in England and the UK?
The legal framework in the UK around disability is complicated, and the threshold to meet the definition of disability is low, so it's quite common for claims to arise. They can be particularly problematic in circumstances where you've got mental health issues, particularly the common trend we see is around ADHD and autism, and establishing whether or not those may meet the definition can be quite difficult. But looking at the clip in question, it seems relatively clear that this would be a disability case just based on the obvious limitations he has. So the main obligations of an employer are to make reasonable adjustments to remove any substantial disadvantage, so quite similar to the reasonable accommodation requirement in the US. They must also not treat an employee unfavourably because of something arising from the disability, unless it's both justified and proportionate, but that can be quite a difficult balancing act. There's also protection from being harassed related to disabilities you might expect. And here, just looking at the clip again, you could quite see that the Bates could argue that the first floor room should have been adjusted to a ground floor to remove the problems he had with the stairs. That's its most straightforward, removing the impediment he has, unable to climb the stairs easily.
Nick, I have a question about that. So Bates keeps saying, I'm fine, I can manage, I'm fine, I'm going to be fine. In the US, an employee has to request an accommodation or make it kind of obvious. They may not have to use any particular magic words, but they do have to make the request. And the request has to be related to their job. It's not just, I need an accommodation just because I need an accommodation. In the UK, does the employee, like in a situation like this where Bates basically says, I don't need any accommodation, does that end the analysis, or do you have to give an accommodation anyway?
It would really turn on that case whether it was reasonable not to provide it in circumstances where the employee had said, actually, I'm okay, I don't need any help here. What you do find on occasions is employees will either be masking things or not giving a full account because they don't want to think the employer might then treat them unfavorably because of a disability. So in those circumstances, it's usually pretty wise to get some kind of professional input, occupational health advice, a doctor or similar, and that way you can get a much more objective, independent view as to whether there is an accommodation required or you can take the employee at their word. But in general terms, unless it's really obvious that what they're telling you is not correct, you're usually entitled to take it at face value.
It's really interesting because I think here, if you were to sort of go against the employee's wishes and try to sort of foist an accommodation on them, that could become problematic under the law. So that's one big difference. So later on in the clip, or after the clip, some of the staff discover Bates uses a leg brace to help his limp, and they try to force the matter by attempting to expose it to the Crawley family and lead to his dismissal. Of course, having coworkers and an employer involved in an employee's personal medical details raises privacy concerns. In the US, the Americans with Disabilities Act governs certain employee data related to medical conditions, and there's also HIPAA, which doesn't necessarily always apply to employees in the employment context, but sometimes may in certain circumstances. So otherwise, here in the US, privacy is largely governed by state law, if at all. I do think that that's somewhat evolving here in the US. How does that differ from England? I know it really does.
The data privacy rules in the UK under GDPR and its sister, the Data Protection Act, are very pro-employee and really quite process-driven. So it's quite easy for an unwary employer to trip up across them. Health data, as you might expect, is subject to a high level of safeguards and protections. So it can only be processed that's used by the employer if either the employee has given free and informed consent, which is fine, but consent can be withdrawn at any time, or the employer is able to show it is necessary to comply with employment law rights and obligations. An example here might be if Bates was having difficulty at work due to the leg problems, and the Crawley family decided they wanted to obtain a medical report to advise them on any adjustments or accommodations that they needed to make. In that case, they could rely upon it as being necessary to comply with their duty to Bates as his employer to make accommodations for him. One particular feature for employers is the ability on employees to make what are known as data subject access requests. That requires an employer to provide all the employee's personal data, so basically anything from which they can be identified, and they have to give it to them with very, very limited exceptions. Usually now know when a dispute with an employee is looming, as it's almost the first shot fired. The employee says, give me all my data. I want to see what you've got. I want to see if there's enough evidence to see if I've got a claim against you. Given the vast proliferation of methods of communication in the workplace, emails, Teams, Slack, WhatsApp, text messages, the whole lot, This can give rise to what amounts to a very substantial quasi-discovery request with all the time, cost and effort that goes with that. It's also led to advice to clients being dance like nobody's watching and email like you're reading it back in court.
I love that. I do think that resonates with employers. Be careful what you say in emails, but I do think that employees and frankly, employers tend to be a little bit looser when it comes to things like text messaging. And that often leads to liability here in the US. So all those different methods of communication really can be very problematic.
That's right. Even if there's not in the US the automatic obligation to give those things over to an employee at any time, once you get into litigation, it's discoverable. And that can definitely trip people up. And then I think sometimes employers forget in the US, certain states have personnel file access laws that require you to give employees their personnel files on request, certainly much narrower than GDPR. But I've definitely had employers be surprised when they've got somebody working remotely from a state that gives a lot more employee access than the state that they're headquartered in.
Yeah, and then it becomes an issue of what is actually a personnel file and what should go in that file or not. And some state laws are not all that clear as to what should be in the file.
It's a tricky area. But ultimately, the Crawleys stand by Bates's hire, and he's offered a position with a formal letter outlining all the terms of his employment. And of course, in the US, this is pretty different from how most employees are typically offered their role. Generally, there's, in the absence of a written contract stating otherwise, an employee is employed at will, which means the employer or the employee can end the relationship at any time for any reason, so long as it's not an illegal reason. So while it's pretty common for an employee to get something like an offer letter outlining potential terms of employment, there's no contractual right most of the time to any of those things or to continued employment at all. So how does that compare? Is modern English employment law still as contract bound as Downton Abbey?
Well, it has moved on over time, as you'd expect. So there's no longer quite the sort of master-servant distinction that we can see in the clip. But every employer must still provide a written statement containing basic terms within 2 months of an employee commencing work. However, the requirements on that are not terribly onerous. It needs to set out just the very basics like legal identity of the employer, work location, pay and benefits, vacation entitlement, hours of work and notice periods. And because that's actually quite limited, in most cases, employers supplement this and have something much fuller, covering things such as intellectual property, confidentiality, garden leave, non-compete restrictions, and so on, because the source of the employer's rights against the employee is pretty much just limited to what's in the contract, whereas the employee typically has a full range of sort of statutory rights against the employer. So it's very much in the employer's interest to try and set out their best position in the contract, as that gives them usually the best protection. Moving on slightly, an employer is generally free to terminate employment for convenience at any time within the first 2 years, simply by giving the notice the contract requires. There are obviously exceptions to that, most commonly discrimination, whistleblowing, that there's a few others as you would expect. However, from 2 years onwards, it becomes really a lot more involved. An employer has to both provide a fair reason and follow a fair process. I'll come a little later of what the fair reasons and processes are, but if they don't do that, then the penalties can be pretty significant. Employees able to cost loss of earnings up to about $160,000 equivalent, or 12 months basic salary if less. So again, there's quite a strong incentive there to keep employers on the straight and narrow. It is all quite process driven. There are lots of things you need to look at in determining what a fair process is. That's likely to be any requirements in a disciplinary policy or procedure the employer has in place. And there are general standards of fairness issued under a sort of governmental code of practice. So in terms of fair reasons for termination, we have misconduct, fairly self-explanatory, bad behavior, capability, that's either not able to do the job to the standard required, so bad at the job, or capability in terms of ill health. They simply can't do it because they're no longer able to do it. Redundancy, illegality, or a sweep up of what's called some other substantial reason. And that covers other areas that you couldn't fit into the other ones. Common examples might there be the expiry of a fixed term contract, or where you have a breakdown in trust. So it's not quite misconduct, but there's a serious enough trust issue there to justify that. In terms of how much notice needs to be given, assuming we're not talking a full cause dismissal, notice periods are either 1 week for each completed year of service, up to a maximum of 12 weeks, or any longer period the contract itself specifies. And of course, the employer is the one that tends to take that. Mandatory termination benefits are modest at best and only required when an employee is terminated due to redundancy. So if it's a conduct reason, you don't need to provide any benefits there. In terms of how it's calculated, it's set by a formula which captures both age, length of service, and a capped weekly pay amount. But it's really not very generous, and employers quite commonly voluntarily enhance this, quite often in return for a release of claims, which makes a lot of sense in many cases.
One question I have in hearing this is knowing that the protections become so much greater once you hit that 2-year mark. Do you see a lot of activity as employees approach that, with either employers looking to come up with a reason to terminate or employees saying, I'm going to raise a protected claim? Or is that me being too cynical?
You would tend to think so, wouldn't you? It happens less commonly than you think. It tends to be more employers will take a decision maybe at the end of a probationary period of, a few months. And after that, what you tend to find is that they don't act before the 2 years mark, perhaps having some reservations or being reluctant to do so. They then hit that 2-year threshold and suddenly it's like, oh, crikey, I wish I'd acted beforehand, but now I've got to go through all the process. So it actually tends to work out the other way.
Very interesting.
I was kind of smiling when you were saying how the mandatory termination benefits are modest, because here, honestly, first of all, severance is never required. And oftentimes it's pretty typical for a company's severance package in exchange for a release to be 1 week for every year of service up to 12 weeks, which I think our clients believes to be very generous rather than to be modest. So, very different. And what we've heard from some of our guests from other countries like Canada comes to mind in terms of this concept of mandatory termination benefits that are just not a thing here in the United States, other than with the caveat, if it's a group termination that rises to the level of a WARN Act, it reaches the threshold for the number of staff, then 60 days notice might be required, or certain state laws have other notice periods that would have even mandatory severance, such as in New Jersey. What about larger terminations in the UK, like a layoff or a reduction in force? In the show, the Crawley family is contemplating a reduction in force among their staff in the wake of World War I. Other than the WARN Act, are there any special rules for those types of situations in the UK?
It's not dissimilar. It's done by threshold. So if an employer proposes to dismiss 20 or more employees at a single establishment, that's typically an office, factory, other place of work, in a rolling 90-day period, then it must offer collective consultation in advance to the affected employees or any recognised union if there happens to be one. And that consultation period must last for a minimum of 30 days. And if you have a larger threshold, if you get to 99 or more, then the period of consultation is extended to 45 days, and dismissals can't take place before those consultation periods have expired. So it sort of elongates matters quite significantly. It's one of the very few areas where the employer can actually get into criminal trouble. There's a required filing called an HR1 that must be sent to the government in advance of that. And if you don't do that, that's actually a personal criminal offence for anybody found at fault. So that's one of the very few areas where an employer can get into proper hot water. In addition, there are quite significant penalties for failure to comply. The idea is that you should comply, and if you don't, then there can be an award of up to 90 days pay per employee. And of course, if you start multiplying that up by any number of employees, that number gets pretty big pretty quickly.
Absolutely. Turning to the topic of wages and hours, and we'll listen in on our next clip where we get a little bit of a behind-the-scenes look at some of the Downton Abbey characters describing a day in the life of the Crawley family's staff, where they wake before dawn and work all day and through the night with no days off. Let's take a listen.
My typical day, I wake up at about 5. I have to go and do all the fires in the whole house. I have to sneak into everyone's bedrooms and try and do their fires while they're asleep. How awful is that? Then, after I've snuck into everyone's bedrooms upstairs and made the fires so they're nice and warm when they wake up, I have to come downstairs and wake all the servants up, which is not a good job because everyone hates you when you're banging to wake them up.
Well, she gets waken up first of all at about 6 o'clock in the morning, get dressed, look presentable before I head downstairs, and we would go to the drawing room or the library and we'd open up the shutters, we'd plump up the cushions, we'd make it look lovely and presentable for the family.
We get ready very quickly, go and oversee a bit of cleaning and making sure the rooms were ready and the dusting, and wait for one of the bells to ring, which means one of the girls has woken up.
And they're off.
I come down to the kitchen because the main thing is we've got to feed the servants first. Are the tea trays ready?
All ready, Mrs. Patmore.
And then we have to make sure that everyone's prepared and ready for the big breakfast for upstairs.
Mrs. Hughes gets up to make sure all the housemaids are doing their duties properly, whilst the family are down having their brekkie. That's very late in the day. It's practically brunch by the time they all get up.
In the US, the Federal Fair Labor Standards Act sets minimum wage and overtime rules, at least for workers who are not exempt from the law's coverage. And some state laws also set requirements in this area for things like mandatory meal and rest breaks, and some states even overtime pay for working more than 8 hours in a day or restrictions on working consecutive days without a break. Also here in the US, while many employers do offer vacation or paid time off just as a matter of policy, there's actually not a legal requirement to offer paid vacation or holidays here in the US. Though certainly many states are starting to step in to fill the gap. For example, Illinois and its leave for any reason law. And of course, many states require leaves, paid or unpaid, for other reasons such as illness, voting, jury service, blood donation, and etc. How does that work in England and the UK?
In terms of hours of work, we have what are called the working time regulations. They've been around for a long time now, and they cover much of this in terms of hours. So they provide a minimum of paid 28 days of vacation per year. That's inclusive of our 8 public holidays. So for a full-time worker, that's 20 days paid vacation plus holidays.
All right. That's it, Emily. We're moving to London.
We got to move.
Well, you're welcome here anytime. They also set down the hours of work, and there's a maximum 48-hour working week unless the employee opts out of that, but that's got to be a voluntary, freely given opt-out. They also set down daily and weekly rest breaks. So broadly, 20 minutes break every 6 hours, 11 rest hours a day, and 24 hours in any 7-day period. There's lots of other rights to time off as well, but most of that is either unpaid or paid at a very low rate. So for example, for sick pay, it's unpaid for the first 3 days, and from day forwards onwards, it's paid at about $150 a week. So not really even subsistence level, even when taken against sort of national minimum wage. So for that reason, many employers supplement this under the employment contract and pay more. Something more typical would maybe be 4 weeks in any rolling 12-month period at either sort of full salary or half salary. That would be much more typical. Of course, the government is very much more generous. If you work for main government departments, you get 6 months at full pay and then 6 months at half pay, which is quite a change to the private sector.
Wow.
Those rules that you were just talking about with the mandatory vacation days and daily and weekly rest breaks, do they apply across the board to all employees or just to certain categories of employees like here in the US?
They apply to all employees, but there are some exceptions. If you are a chief executive or a C-suite, you may be what's called an autonomous managing executive, that you're able to set your own work hours, in which case they're exempt from the bulk of that. There are also further exceptions for special cases for things like defense, doctors in training, pilots, where it's much more difficult to manage the working hours. So there are some exceptions that are either full exceptions or partial exceptions, but usually it's the case that you're required to give compensatory rest if and when you go above that.
So professional employees beyond the C-suite, generally speaking, have a maximum 48-hour work week unless they opt out. Is that how it works?
That's right, yes. In practice, in almost every professional environment, banking, accountancy, financial services, law, people do it as a matter of routine. It's part of the deal of working in a professional environment. It is always possible you can opt back into that. If having you opted out, you can then freely opt back into it at any point on 3 months' notice. But as a matter of practice, most people accept it as part of the work deal.
So one area where other countries are famously more generous than the US is parental and family leave. Here in the US, under federal law, larger employers, those with more than 50 employees within a 75-mile radius, may have to offer unpaid but job-protected leave under the Family and Medical Leave Act. But otherwise, there is no requirement for leave under federal law, though, of course, again, as Emily mentioned earlier, some states have stepped in to fill the gaps. How does that compare to the UK?
We have very comprehensive family leave rights.
Of course you do.
They cover a range of scenarios, maternity, as you would expect, but also paternity, so that's for the father of the child. Adoption leave, so if you're adopting a child, you get effectively the equivalent of maternity leave. We have parental leave, we have emergency caring leave, so if you're caring, for example, an elderly relative or a child and the existing care arrangements break down, you're entitled to emergency time off for that. And we have a concept of what's called shared parental leave. And that is, I think, perhaps a bit more unique. And that's where a mother who has had a baby can shorten her 12-month paternity period and give that to the father instead. The idea being that they want to encourage, as a matter of sort of policy, fathers to bring up or have more involvement in a child's early development. And so for that reason, the mother can choose to go back to work and effectively gift what would have been the rest of maternity leave to the father. Sounds great in theory. In practice, the take-up rate is about 2 or 3%.
Is that only when the parents both work at the same company, or is that?
No, they can work cross companies. So if my wife works at another law firm around the corner and she had a baby, she'd be entitled to give the rest of her maternity leave to me, provided she returns to work.
Interesting.
We also have some quite new developments in this area. We have recently introduced a parental bereavement leave for where you have the death of a child or a stillborn baby, and also neonatal leave where there's a premature baby and it requires special care on an ongoing basis, as is quite sadly often the case. The entitlements to those are a bit patchwork, depending whether you're an employee or have other status, and what the qualification periods are, and whether it's paid or unpaid, and how long it lasts for. So it's all there, but whether you might qualify for it is perhaps a different matter in some cases.
Makes sense. Shifting gears to one more topic, discrimination and harassment and employment claims. So in our next clip, we'll hear a tough conversation between the character Thomas Barrow and the head butler, Mr. Carson. And of course, Thomas Barrow is noted in this show, Downton Abbey, for struggling with the fact that due to the times he lives in, he must keep his homosexuality a secret. At the time, it could have even been considered a criminal offense. So let's listen in.
I hope you're not planning to hit me with that.
No, but I will not beat about the bush either, Mr. Barrow. Someone has reported that you seem to have a private understanding with Andrew.
Not this again.
I might not have given it much mind, but I was upstairs last night quite late and I saw him leave your room.
Mr. Carson, how long do I have to work in this house before I'm given any credit?
That is all very well, but we're talking about a vulnerable young man and I must look to his welfare.
Yes, and if I were to give you my word of honour that nothing took place of which you would disapprove?
If I could just be sure.
So my word is still not good enough, Mr. Carson. After so many years.
I only wish it were.
The show has some other examples of discrimination, including, for example, and not really employment related, but the fact that under the laws at the time, male primogeniture, see if I pronounced that correctly, Tracey, for hereditary titles, the Earl of Grantham's estate could only be inherited by a distant male relative and not by any of his daughters. And that is, of course, a major source of conflict on the show. But in the employment setting today, of course, discrimination on the basis of a protected class, including sex, gender, sexual orientation, is illegal. So how are those laws enforced in England and the UK?
The onus has historically been very much on individuals to bring claims if they felt they've been discriminated against. But from April next year, we will have the creation of what's called the Fair Work Agency, and that will have a remit to bring claims on behalf of employees, rather oddly, whether or not the employee wants the claim to proceed. So it remains to see how that's going to work out. But it is a significant change, although quite how active it will be and what its funding arrangements will be is a bit of an unknown factor at the moment. So the primary legislation we have here is called the Equality Act, and that sets out very similar protected characteristics to those that you have in the US: age, disability, sex, pregnancy, maternity, so on and so forth. But there are a few slightly more unusual ones. We have what's called race, religion, and protected philosophical belief. And the protected philosophical belief has developed through case law over the last sort of decade or so. And it's really developed into some interesting, surprising, and perhaps slightly controversial areas. So some examples are environmentalism and climate change, ethical veganism, gender critical belief that sex is immutable, and even indeed, quite extraordinarily, anti-Zionism. So it's fair to say that these are not without their controversies, and quite often they end up in disputes between different types of protected characteristics. So one we see played out fairly regularly at the moment is the gender reassignment and the protected belief of sex being immutable and cannot be changed. So you can see in those circumstances that creates not quite an immovable object, an unstoppable object, but you can see that sets out a real tension between two different but equally protected characteristics. That said, most matters are very much more mundane, sex and disability being by far the most common. What we do see, though, is because you don't have termination protection for the first 2 years of your employment, it's quite common to see discrimination claims used as a proxy for that. Oh, I got fired because I'm a woman, or I got fired because I have a disability. There is a fairly common pattern to that people see that is a way to try and gain a remedy when they might not otherwise have a claim. But the true concern is actually they were terminated.
That's actually very similar to here, where you'll see, even though there's a concept of employment at will, you'll have employees claiming discrimination as a way to try to get some kind of cash settlement or severance where they ordinarily wouldn't necessarily be entitled to it.
Absolutely. It's very much the same here. And particularly if you see people who are highly paid employees, because claims of that nature are not limited in financial terms, it's very easy to come along to an employer and say, oh, I've been discriminated against. I'm not now going to work for, a year, 18 months, 2, 3, 4, 5 years, and therefore I want compensation for that period. We also have the issue that discrimination claims by their nature are very much more difficult because nobody ever admits to discrimination. So you look at all the circumstances and you have to draw inferences as to who said what and why. And going back to the earlier topic about the subject access requests, looking at how language is used in those behind the scenes can be quite interesting. But that said, most awards are very much more modest, and the 3-year median is around $15,000. But about 90% of cases are settled, so perhaps that's not the full story.
So I think that if we were to sum up our discussion, what we're seeing is that there are some similarities and then some real marked differences, frankly, UK being more generous to employees than the US is in many instances. But the bottom line being that employers who have employees in both countries should really take care to be mindful of the laws of their applicable jurisdiction and consult with counsel as appropriate. Nick, we really want to thank you for joining us today. It's been a really interesting discussion about our country's laws, and we want to thank our listeners for listening in. Check out our blog, hiringtofiring.law, and send us an email. Let us know what you think and suggest topics for future episodes. Thanks so much for listening.
Copyright Troutman Pepperlock, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman does not make any representations or warranties, expressed or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepperlock. If you have any questions, please contact us at troutman.com.